It's never about justice, in my view. It's always about victory. Welcome to Injustice for All. We're going to have a very interesting guest today, Mark Allenbaugh, who is a sentencing specialist. There are different components to the criminal justice system. There's a charging period where you're charged either in a complaint or in an indictment. There's a trial phase where you're either going to trial or taking a plea. And then perhaps the most important part to any person is sentencing. How do we address sentencing? How is it different in the federal versus the state systems? And Mark will be here to help us understand the importance of sentencing and the evolution of sentencing. And I say that because in the federal system in particular, there was a change in the way we sentence people beginning November 1st, 1987. It was at that moment in time that the Congress had enacted what we call the United States Sentencing Guidelines. It had a noble purpose. It was to make sure that every judge everywhere in the federal system handed out an equal punishment to people, no matter race, creed, color, as long as the crime fit within the grid that they created, which included criminal history, the nature of the crime. As long as they fit within that grid somewhere, the sentence should be accordingly what the guidelines had set up. From the day it was enacted, and I was practicing then, I told everyone, this will ruin the criminal practice. No one will go to trial anymore. And that's turned out to be true. Almost no one goes to trial anymore. So there are no experienced trial litigators anymore coming out of the federal system. There are no more experienced jurists, judges who have had trials. A recent case involving a judge in the Eastern District, she's been on the bench for 4 years. This is her second trial. 2 trials in 4 years. It's incredible to believe that. And you have no idea that that's what's happening. But that's true for almost every judge. The system doesn't want you to go to trial. If you could go to trial, and if everybody went to trial, the system would be overwhelmed. There wouldn't be enough judges, enough prosecutors, enough places in prison to house people if they were convicted. In any event, Mark's going to be with us shortly, and we'll talk about his involvement. He was a staff attorney on what we call the United States Sentencing Guidelines Commission, a very important entity in federal sentencing. And he'll explain all that to you. I don't know as much as he does about it, and it'd be better coming from him. So as usual, we begin each program by talking a little bit about what's going on in the system and how flawed and screwed up it can be. And it is continuously, and during this administration, more so than I've ever experienced in the 51 years since I graduated from law school. I would call it tohu bohu, which is disorganized. Everything is disorganized. It's a shambles. I'm a believer, as you well know if you've listened to the program, in being aggressive on behalf of your clients at all stages, pre-charge, during the case, at sentencing, and thereafter if they go to prison, or are the subject of what we call restitution and or forfeiture. All of these are important phases for a client, and it is the job of the attorney to be knowledgeable or bring in people who are knowledgeable to help address each of those topics. The most important thing is being aggressive for your client. In the show, Perry Mason, that I speak about quite frequently, there's a main character who's a prosecutor named Hamilton Berger. There's a main head of the homicide squad for the police called Lieutenant Tragg. And of course, then there's Perry Mason and his investigator, Paul Drake. And I was watching a recent episode in which Lieutenant Tragg said to Perry, "Which side of the law are you on?" And Perry said, "On my client's side." And that is the mark of a good attorney, being on your client's side, not being on either side of the law. You have no loyalty but the one you should be giving to your client. We were talking last week about being able to indict a ham sandwich. And it is the concept that all of us in the criminal field talk about, is that prosecutors have such unfettered authority, discretion, that they could ask a grand jury to indict a ham sandwich, and the grand jury would do so. And believe me, I was in front of grand juries as a prosecutor. Some of our grand juries went for 18 months, 2 years. If you don't think that the grand jurors became friendly with me over that period of time and would have done almost anything I asked, you're misunderstanding the dynamics of that relationship. And that's what happens with prosecutors too, with grand juries. They see them every day. They develop a relationship. They trust the prosecutors to lead them in the right direction. Not always so, but that's the way it is. I mean, it's human nature for grand jurors to look up to the prosecutors. The position of being a prosecutor, a public servant, is so important in our system and has been so abused for so long that, notwithstanding the words of the Supreme Court or anyone else, they are in it to win. They're in it to develop a winning reputation, to be able to go back to a law firm and earn big numbers in salary and bonuses. That's what federal prosecutors are, for the most part, all about. Others are there to rise up within the system, maybe be considered to be the U.S. attorney, maybe to be considered for a judgeship, maybe to be considered to be the Attorney General of the United States. But whatever their reasons, it's never about justice, in my view. It's always about victory. So years ago, a very famous Supreme Court judge, Robert Jackson, spoke of this repeatedly, the importance of the prosecutor in the system. And I just want to read you a few words of what he said back in the 40s. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. The prosecutor can order arrests, present cases to grand juries in secret session, and on the basis of his one-sided presentation of the facts, can cause a citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard. Or he may go on with a public trial. If he obtains a conviction, the prosecutor can still make recommendations as to sentence, as to whether the prisoner should get probation or a suspended sentence, or after he is put away, as to whether or not he is a fit subject for parole or release. While the prosecutor at his best is one of the most beneficent office forces in our society, when he acts from malice or other base motives, he is one of the worst. These powers have been granted to our law enforcement agencies because it seems necessary that such a power to prosecute be lodged somewhere. Justice Jackson went on to say much more than that, and I would commend anybody to look it up. But nonetheless, here we are, 70 years later, and it hasn't changed. His warnings about the powers of prosecutors go unabated. Prosecutors continue to be guided by their ambition, for the most part, not all of them, but many of them, and unfortunately many of them who are appointed by the political process. All of the U.S. attorneys, the person who is the head of the U.S. attorneys' offices throughout our country, are appointed by the president. And that is because they are akin to that president's view of life. And as we have seen in this current administration, he has appointed people who cannot even get through the Congress, who normally have to review any appointment and determine whether or not that person is fit for the office, just like they do with any other cabinet officer. But to avoid that, this administration has appointed people to positions of as U.S. attorney in various states who could never have cleared the Congress and would never have been supported by a vote, even in a Republican-dominated Congress, would never have cleared the Congress. So there is a law that talks about this, and it says the president can appoint somebody to an office, the attorney general, for a period of 120 days without congressional approval. And I'm obviously summarizing what the law says, but when the 120 days are over, they can't be U.S. attorney anymore. Nonetheless, the current administration has forced people to remain in office. I shouldn't say force them, but they have remained in office as the U.S. attorney. But what's happening as a result is more craziness within the system. The federal defender's offices in all of the places where the temporary U.S. attorney has outstayed their 120 days are filing motions to dismiss any case that is brought by the U.S. attorney's office because the U.S. attorney doesn't have the authority to authorize the conduct of his office. It's a mess. And we're going to get into this on a later show. Let me get back to my ham sandwich analogy a few minutes ago. In the District of Columbia, where the current administration has appointed Jeanine Pirro to be the U.S. attorney, Jeanine, who was the district attorney of Westchester County, a suburb of New York City, many decades ago, and then became a TV judge, then became a Fox commentator. That's her credentials. There have been 7 instances in the last 2 weeks where the grand juries in D.C. have refused to indict people, including 2 who had made threats against President Trump. They refused to indict them. One who threw a sandwich, the proverbial ham sandwich, at a member of ICE. they are acting as responsible citizens because they're evaluating the cases and saying, we're not going to be the pawns of a political process. And that is truly what a grand jury is supposed to be. It's a grand inquest, as was said by a Supreme Court judge in the 1930s. It is a grand inquest, and usually their powers are unfettered. They can investigate anything they want, indict anyone they want, not indict anyone they want. And the grand juries in the District of Columbia are doing just what they are supposed to do: evaluate and decide. So our guest today is Mark Allenbaugh. He's a sentencing and mitigation specialist. I'll have him explain to you what that means, but essentially it means that he helps attorneys and clients at sentencing and thereafter to avoid punishment. And punishment comes in various forms at sentencing: a term of imprisonment and a financial penalty, potentially known as restitution and or forfeiture. They're two separate things. We'll get into all that with Mark. Mark is a very knowledgeable guy. He has multiple degrees, which we'll have him explain, and he was a staff attorney with the U.S. Sentencing Commission, maybe the most powerful organization in the criminal justice system in America today. Mark, welcome to the program.
Thank you for having me. I always appreciate the opportunity to speak about our federal criminal justice system, although it's not really much of a system and there's not much justice involved in it. I'm a former staff attorney with the U.S. Sentencing Commission, and now I head up an organization called Sentencing Stats, or a company. It's a data analytics firm. And you may have already mentioned this, but what we do is we provide statistical analysis and input and guidance to attorneys and their clients throughout the United States on federal sentencing issues and post-conviction issues as well, regarding the Bureau of Prisons. I'm not sure if you'd like me to start just like what the Sentencing Commission is.
So I was going to ask you, sentencing, as I was explaining prior to your coming on, there are different components to a prosecution. There's a charging instrument. There's a potential for a trial and or for a plea. And then the most important part to me, sentencing. And since about 97% of all cases in the federal system result in a plea or a conviction, the importance of sentencing cannot be understated. And that's where I would reach out if I were handling a case to someone to get assistance, because very few attorneys understand the sentencing process, in my view. Mm-hmm. And I've been doing this and been around it for 51 years. They're happy if their client doesn't go to prison, but they don't really concern themselves with restitution or forfeiture, and people don't even know what those terms mean.
Or the collateral consequences of conviction too. That's often ignored.
Right.
As well.
So tell us how you came to be running a company called Sentencing Stats, why you're running that company, and what the role of somebody like you is in sentencing.
So I guess the best way to answer that question is just a little bit about what the Sentencing Commission is and how I got to work there. It was my background is actually in philosophy of physics. And I was in law school at American University back in the late 1990s. And there was a fair, a job fair, and there was this interesting little table that had something called the Sentencing Commission. There was the Department of Justice. I knew what that was, Department of Labor, a bunch of law firms. But then I thought, this is interesting, a sentencing commission. one of my majors as an undergrad was English. So I'm thinking, if there's a sentencing commission, is there a paragraph commission? But that was a little joke that we used to say when I was at the sentencing commission. So I spoke to them. They really liked the background, the philosophy, the physics, blah, 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 the data. And so they hired me as an intern, and I kind of rose through the ranks and eventually became a staff attorney there. And what the Sentencing Commission is as I explained offline to you earlier, is, in my opinion, and well, not even in my opinion, I have the data to back this up. It's perhaps the most powerful agency in the United States today that nobody's ever heard of. And it's this little supposedly independent agency in the judicial branch of government. We usually think of agencies in the executive branch, but like the IRS or the Department of Justice, all the hundreds of agencies that are under the executive branch. We don't think of any under the judicial branch, and this happens to be one of the very, very few. But it's also independent. So it's an independent agency within the judicial branch, which really makes it unique. And what it was created back in the early or the mid 1980s. First came into existence back in 1984. It was designed by Congress, or intended by Congress, to create something called sentencing guidelines. There's this rather non-controversial theory, I think everybody would universally agree with, that those individuals that are similarly situated should be sentenced similarly. So if I commit a $5 million fraud in California and I end up getting a 60-month sentence, it shouldn't matter if I did the same conduct in Florida or New York, I should end up getting the same sentence. And what was happening, what Congress understood, and this was not just Congress, but a bunch of federal judges going all the way back to the 60s, 70s, and 60s, was that sentencing was all over the place. And similarly situated individuals were not getting sentenced similarly. It was really, there was no rhyme or reason. It was really ad hoc, dependent primarily on the mood of your judge, who your judge was, your judge's philosophy, et cetera. And Congress thought that that was a problem. So they decided, we really need to regulate sentencing. And it was a bipartisan
and by the way, having practiced back then, it was a problem, because if you got a judge who didn't like people of color, they got higher sentences than those similarly convicted of crimes who were white.
Yes. Yeah, we saw that in the white collar criminal area. And by the way, one thing I should add too, before the guidelines went into effect, the default sanction wasn't imprisonment like it is today. Pretty much everybody that gets convicted of a felony ends up doing some time, whether it's a month or 10 years, they'll do some time. The default sanction, though, back before the guidelines came into effect, was probation. And most individuals, including those that were affluent and white and et cetera, would receive a non-custodial sentence, to use the technical jargon, basically probation. They would get a big stern warning, you're looking at 10 years if you don't behave yourself, but we're going to give you a chance. And most individuals, was close to 60% of those that were sentenced prior to the guidelines received a non-custodial sentence. Congress also thought that was a problem too. Not enough individuals were getting in some term of imprisonment, they thought. And this, what I was about to say, is this was both sides of the aisle that saw this as a problem. It wasn't just Republicans or Democrats. As a matter of fact, something called the Sentencing Reform Act is what created the Sentencing Commission, which created the guidelines. And that act was championed by the two strangest bedfellows, Senator Strom Thurmond on the very far right and Ted Kennedy on the very far left, if you will. But they were both the original co-sponsors of the legislation that created that. So what the commission was designed, it intended to be 7 judges primarily, although it doesn't necessarily need to be judges. And it hasn't always been judges. There have been private attorneys or professors that have also sat on as commissioners, but 7 individuals with a staff of about 90 or so individuals, and that's remained pretty consistent over the last 40 years, would create and did create something called sentencing guidelines. And these guidelines originally were binding on judges. And what the guidelines did is the commission originally looked at data and said, okay, what are judges sentencing individuals for fraud to, or drugs, or sex offenses, things of that nature. They would just look at broad categories and then try to identify from the data that they had at the time what were the important factors that judges were taking into consideration when imposing a sentence. So, for example, in fraud cases, it was primarily the loss amount, or how much money was involved, how much money was stolen or embezzled, or things of that matter. Drugs, it was the drug amount. Tax, it was the tax loss. Also, like the number of victims and what role the defendant had in the case. So those were factors that the commission saw rather routinely that judges were taking into consideration and weighing them to varying degrees. So what the commission did was, okay, we're going to come up with these rules for particular types of offenses, and we're going to identify what we call specific offense characteristics. They're basically little variables that judges now are to consider, and we the commission, are going to assign a weight to them. So, for example, if the individual had a leadership role in the offense, this was a conspiracy to defraud the government of something, and somebody was a leader, they would get +4. They would have an offense level increased by 4 levels. And so what the commission did is had all these different, they call them the guidelines because there are many guidelines for different types of offenses. And each of these guidelines takes into consideration different types of factors. And ultimately what it does is it spits out a number between 1 and 43, 1 being the least severe or the least serious type of offense, and 43 being the most serious. And then the commission also created what are called criminal history categories, depending on the criminal history of the defendant, 1 being the least serious, 6 being the most serious if somebody happens to be a recidivist. And so it created this, what's called a sentencing table. So once you apply the guidelines, you as the judge, you come up with a number, then you look at this, the criminal history of the defendant, and that will spit out a category. And you look at this chart now, and you go down the chart on the y-axis, which is for the offense level, and then the x-axis for the criminal history, and then out will come like a very narrow range of months imprisonment. So, for example, if you were at a criminal history, let me see, I'll just pull something up here. If you had like an offense level of, let's say, 18 at criminal history category, in criminal history category 1, your sentencing range was 27 to 33 months. And that was binding. That was binding on the court. So the judge had the discretion to sentence anywhere within 27 to 33 months. He could give you the low end of the guideline range, or she could give you the high end. But the discretion that the judge had was very narrow. It was just within that range. And the range generally was just a matter of months. Once you got up to like really high offense levels, like 40 or 41, then it kind of expanded to a few years. But it wasn't like you see in state courts where somebody would get a sentence of 5 to 20 years or something like that. The other thing that the Sentencing Reform Act did was it got rid of parole. And at the state level, we still see that a lot. And a lot of states have parole where you get what's called an indeterminate sentence. A judge will impose a sentence of 5 to 20 years, but it's ultimately up to the parole board to determine how long you actually serve. The Eric and Lyle Menendez case has been in the news lately because they've been seeking parole for their I think they got life terms, but they're parole eligible. So a parole board can determine when, if ever, they're going to be released. That's not the case at the federal level since the Sentencing Reform Act went into effect back in 1984. So the first set of guidelines came into effect back in 1987, and they, like I was saying, they originally were binding on the courts, but then back in 2005, the U.S. Supreme Court, and this has been an issue that was percolating for quite a while, said that the guidelines were unconstitutional, at least in a binding nature. And the reason, the gist of the reason that the Supreme Court gave was, if every little factor a judge is deciding increases the offense level, and it results in a narrow range, like I was saying, like if you're at offense level 18, a judge can only give you 27 to 33 months. But if you're at a 20, then it goes to 33 to 41 months. And that was binding on the court. Each of those little factors was essentially a new crime, according to the court. And so each of those factors must be, because it was a crime, they actually were elements of an offense and not a sentencing factor. And I don't want to bore everybody, get into all the philosophy behind what a sentencing factor is and an element of the crime. But at the time, it really wasn't obvious. And frankly, it still really isn't obvious. And the Supreme Court has long struggled in coming up with a clear definition of what delineates the two. But nonetheless, what they did say is, at least in this case, we have binding guidelines and all these little sentencing factors. And while it might make good policy sense, it violates the Sixth Amendment. It violates the Sixth Amendment in terms really of notice and right to a jury trial. If I am charged with a fraud case, but the loss amount is not charged in the indictment and the jury doesn't have to determine it, and it's really just up to a judge, and that affects my sentencing guidelines, and the loss amount is very important, it still is for, in fraud cases, then the Supreme Court said, well, that violates the Sixth Amendment. So the sentencing guidelines are unconstitutional. But then the Supreme Court did something that nobody expected. And that was state that the guidelines, we're going to fix the guidelines, the Supreme Court said, rather than just leaving it to Congress, which, in my humble opinion, they should have. And several members of the court thought the same, that we shouldn't get into legislating from the bench, so to speak. But they did something that nobody saw coming and nobody asked for. The issue before the court was whether or not the guidelines were constitutional or not. And that was it. Nobody asked for a fix. They thought, either the commission working with Congress could fix the guidelines if they were unconstitutional. But instead, what the court did is took it upon itself and said, we're going to say that the guidelines now are merely advisory. So you don't have to follow them. You still must calculate them and go through all this, the difficulty of determining what the total offense level is in the criminal history category, but you don't have to follow them at the end of the day. You have to consider them, but you don't have to follow them. And Scalia famously said in a dissent, this was in the Booker case, said that, well, this is going to create a discordant symphony among sentencing. In other words, sentences, if judges didn't need to follow the guidelines, sentences were going to end up all over the place. And sure enough, that is exactly what happened. So some judges follow the guidelines, others don't. And those that don't follow the guidelines, the term now that we use is a variance. They'll sentence below the guidelines to different levels. Some judges will go below the guidelines 50%, others will do 80%, still others 30%. So sentences for those that are identically situated, that have the exact same guidelines calculation, can nowadays have widely disparate sentences. And there's no rhyme or reason to it other than we're back at the pre-guidelines era. But it's arguably worse, because in the pre-guidelines era, you didn't have to litigate all these sentencing factors and go through all this stuff. But now you do. But then it's what I use the term kabuki theater. You have to go through all this rigmarole, ostensibly because you're trying to bring rationality to sentencing. But then throw all that out and we'll just go with something else ultimately to impose sentencing. So that's where I come in. That's where sentencing stats comes in, and why I believe statistics are so important nowadays, because what is a judge to look at? If a judge wants to, well, one of the charges that Congress gave to judges as part of the Sentencing Reform Act, it did create the commission, but it also told judges two things. You are not supposed, well, told judges several things, but one of the two main things is to always impose a parsimonious sentence, impose a sentence that's sufficient but not greater than necessary to meet the purposes of deterrence and incapacitation, retribution, and rehabilitation, the four classic philosophies of sentencing, if you will. But they didn't really define all of that. But the other thing that's more important is they said you have to avoid unwarranted sentencing disparity. And by unwarranted sentencing disparity, this was sentence similarly situated individuals similarly. But if the guidelines aren't binding and everybody's sentencing all over the place, what's a judge to do? What's counsel to do? What is a reasonable sentence? What's a parsimonious sentence? Well, luckily, one of the great things that the commission has done, it's done, in my humble opinion, a terrible job with the guidelines, but it's done a fantastic job in collecting data. And since its inception, it was born out of data. As I mentioned before, the commission looked at past practices when it first promulgated the guidelines back in 1987 is when they first came out, November 1, 1987. So we're coming up on the 40th anniversary now of the guidelines. But one of the things that they did do is collect data quite well. They have what's called a monitoring data and monitoring department within the Sentencing Commission, and it collects hundreds of variables on every single individual that's sentenced under the guidelines. And that's great because now you can look at not just what an individual was sentenced to, but age, race, which can still be a factor, sex, which can be a factor, education, citizenship, all these little variables that are not in the guidelines themselves, but can still can still be a very important factor at sentencing. So what we do at Sentencing Stats is we have access to all the data are published publicly in massive data files. And we make sense of those data files and make them coherent and provide them to counsel and their clients and the courts with an analysis. Okay, here's what sentencing looks like. And I can give your audience just a quick look here about one of the things that we do.
Let me take you back a little bit
Sure.
for some clarification for the uninitiated, which includes most of the members of the legal profession. The sentencing guidelines is essentially a chart.
Mm-hmm.
On the left side tells you the 1 to 43 that you mentioned.
Yes.
And on the top going across is your criminal history, essentially.
Correct.
And so a judge would say, all right, here's what the guidelines tell me about this. And that's the number on the left. And then I look across to the right as to the criminal history. That's where my sentence is going to be, in that range. Now, just maybe as an interesting way to explain this, the guidelines addressed as well the different crimes, all the crimes that are in the federal spectrum. So maybe the easiest is drugs for us to understand. If you were convicted of possessing drugs and there's the guidelines right there.
Yeah.
And we can see that chart. And if you were convicted of, the guidelines would tell us if you had 1 kilogram, it was in this range. If you had more than 5 kilograms of cocaine, it was here. If you had more than 1 kilogram of heroin, it was this.
Correct.
And if you had 50 kilograms, it was the next level. Then that would tell the judge 50 kilograms of cocaine was level 36. I'm just making this up, but that's
Right.
about
Right.
what it is.
Hmm.
Level 36, you'd look on the left side of a chart, then you'd look across at what the criminal history was. That's a sentence.
Right. That's right. That's the way it was supposed to work in theory. And it did work that way up until 2005. There were some exceptions to this. Something called downward departures, where
Explain what that word, those words mean.
okay,
Downward
so
departure.
a downward departure, the commission realized it could not account for every possible permutation of how an offense was committed, or every possible factor of a defendant's background that could be relevant to sentencing. So it allowed, in rare cases, and they had to be kind of an extreme case, for something called a downward departure, which allowed judges to sentence below the guideline range. And there were also things called upward departures, which also were equally rare, actually even more rare, where judges in very extreme cases could sentence above the range. And the commission identified grounds for those. Usually one of the big areas was what's called a 5K 1.1, which still exists, and that is on motion from the government. If the defendant had provided substantial assistance in the prosecution of another person, then they could be eligible for a downward departure based upon substantial assistance. And that was the major ground for sentencing below the guideline range. But other factors could involve medical issues, like extreme medical issues where the defendant may be dying, stage 4 cancer at sentencing. That could be a ground for a downward departure. Perhaps the most famous example had to do with the Rodney King beating back in the early 1990s out of Los Angeles, where four LA police officers were prosecuted federally for violating Rodney King's civil rights when they pulled him over and they beat him up. The judge at sentencing for the lead defendant, Stacey Kuhn, departed below the guideline range because the extreme factor that the judge identified there was that he was a cop, and cops don't do well in federal prison. They don't do well in state prison either. And so because he was going to have to serve harder time than the usual person, because not only was he a cop, but it was a notorious case. It caused a massive riot and all this stuff. So the judge went below the guideline range. That got appealed by the government and went all the way up to the Supreme Court. And the Supreme Court said, no, that's okay. The downward departures based upon this issue are fine. Very controversial, but nonetheless, it was just to prove the point that the commission can't think of everything, but nonetheless, downward departures were there kind of as an escape clause, but they were very, very rarely used, and they were always challenged by the government. If in the non-5K 1.1 context, they were always challenged by the government.
Before I get you to define the word variance for
yes,
that you use, 5K 1.1 in the vernacular is if somebody is a cooperator or a rat and offers to testify for the prosecution or helps them make cases. The prosecution says at the end of the case, after the other people are prosecuted that you've provided substantial assistance against, we will file a motion pursuant to 5K 1.1 that will tell the judge what a wonderful human being you've become, and therefore you don't deserve to be sentenced like the other defendants.
Mm-hmm.
It's really one of the worst misleading of the jury. What prosecutors do is they put a person on the witness stand. They say, have you pled guilty to this crime? And they say yes. And are you expecting some help at the end? And they say yes, but they don't tell them, or they don't tell the jury how far they're willing to go to help
Right.
this person and
Yeah.
what that person's expectations are. And criminal defense attorneys try to say, well, you expect to get a lower sentence. Yes. But the prosecutors already know what they're going to write for this person. If there's a conviction, they're going to write that they were the greatest. And so that was one function of the guidelines, is to permit an exception to the rule. There were others that came upon the commission over the course of time, 5H 1.4, this and that, which are
Right.
different sections of the guidelines that say, listen, you can take into account family circumstances, you can take into account this or that. But this is an evolving process, and that's why we have the Sentencing Commission to consider all this. And
Yeah.
they do every year, as far as I know,
Yes.
consider things that they had never thought about. And they issue what we call commentary. So I'm going to ask you to tell us about variance and tell us about the commentary that the Sentencing Commission offers us and how that's important in terms of determining sentences.
Very, very, very good questions. Well, I'll take the easy one first, and that's the variance. So after Booker in 2005, when the Supreme Court said that the guidelines were merely advisory, a new term just kind of arose out in the field. And that was an alternative to a departure, what was called a variance. Basically, they were the same animal. It's just that the reason why the variance terminology developed was judges were going below the guidelines now because they were not limited to the grounds that the commission identified for downward departures, age, illness, or substantial assistance. Now the Supreme Court said courts could go below the guideline range for disagreeing with the philosophy of the commission. What the grounds for why the commission promulgated the guidelines the way they did. That was a legitimate reason. They just, I just have a policy as a judge. I just have a policy disagreement with the commission on how they're sentencing drug defendants, and that was allowed. But that wasn't a classic ground for a departure, so everybody started calling them variances, and that took off. As a matter of fact, then variances, both downward and upward variances, which by the way are still rare, but downward variances exploded. Before, as I was mentioning, a downward departure was very rare. Downward variances, once the guidelines became advisory, just went through the roof. A big example that would surprise a lot of people is in the child pornography context. Most individuals that when you first say that child pornography have an immediate natural revulsion to that. It's the worst of all possible offenses, et cetera. But judges, even very conservative judges, recognized that there were some significant problems with the child pornography guideline. And one of the biggest problems is they had no empirical basis. In other words, the commission had drafted that particular guideline, and others, frankly, but that particular guideline got a lot of focus because so many individuals were getting maximum sentences. And a lot of I could already hear them out in the audience. Oh, fine, they were child pornography offenders, lock them up, throw away the key. But that's not the way federal sentencing works. And you have to make a distinction between those that actually like produce child pornography versus those that just view it or just happened upon it accidentally, et cetera. And there are many nuances in how defendants commit crimes and their backgrounds and stuff like that. That particular guideline, as well as others, weren't taken into consideration. So judges started varying below that guideline significantly, so much so that less than 30% of sentences now under the child pornography guideline are within the guideline range. There's 70% are below that guideline range. The fraud, in the fraud context, those also have seen a marked increase in downward variances for the same reason. There's not a lot of, even though the fraud guideline is very sophisticated, and some call it a mini guideline because there's so many specific offense characteristics, and it's very involved and complicated to go through just that particular guideline. Nonetheless, judges have recognized that there's not a lot of empirical support for these enhancements. Just to kind of go back to the amendments that you're talking about, the commission does amend the guidelines every year based upon input from the public and the Department of Justice and other experts out in the field. But one of the things that has always kind of rankled the feathers of the defense bar is there is an ex officio commissioner on the commission from the Department of Justice. And by ex officio, basically, it's a non-voting member of the commission. You have your 7 commissioners, but you also have 2 non-voting commissioners as well, one from the Department of Justice and one from the I can't believe it's still around, but the old parole commission for those very few defendants that still are under the old system, the pre-1984 system, where there was still parole at the federal level. So the problem that some have argued about having an ex officio member of the Department of Justice as a commissioner, even though they're not voting, they're still a commissioner, is there's too much influence there from the Department of Justice, and they always want to ratchet up the sentences and never down. And that's the truth. I mean, that's just empirical. Over 90% of amendments that the commission has promulgated over the last 40 years have always ratcheted the guidelines up. And there's only been one in recent memory where it's gone down, and that had to do with 0-point offenders and other stuff.
When the commission issues the guidelines, there are the written guidelines, and then at the bottom of the guideline, there's something called a commentary.
It's a really good question because it's a very important issue right now. It's been in front of a lot of the courts, and so you have the guidelines. And let me just get an example here so everybody can see what we're talking about, so it's not so abstract. We're at the Sentencing Commission's website here, and you can access the guidelines here. And we can see there's all these different types of offense conduct. I'm just going to go to kind of an easy one, and that is the fraud guideline at 2B 1.1. And so we can see here, this is the way the guideline would operate. So you have a fraud offense, let's say bank fraud or wire fraud is probably the most common one. You go over here, you start out as 7, and then you look at what's called the loss table. I mean, how much fraud was involved. And depending on the amount, you could see these differing amounts give you different increases. So if it was $1 million fraud, you look here, more than 550,000, but less than $1.5 million, you add 14 levels, so on and so forth. And you can see
what does that term mean, Mark? Levels.
Okay, the levels go to, remember that guideline table that we're talking about, the 1 through 43. That's what the levels refer to.
That gives you the number on the outside running down.
Correct.
Versus the criminal history across. Okay.
That's correct. That's correct. So you get levels, you get offense levels. That's that 1 through 43. And then you get criminal history points. That has to do with the 6 categories across the x-axis. So at any rate, so we have all this terminology here, all these different things. If the offense involved a theft from another person, you increase by 2 levels. So on and so forth. And then at the bottom of the guideline, and this is perhaps the most complex guideline. You don't see so many different specific offense categories generally. So once you get down to the bottom of the guideline, you have something called the commentary. And what the commentary is supposed to do is basically explain. So it provides definitions and and it also has what are called like application notes. So essentially, how to apply it. It's supposed to help the judge and the parties apply the guidelines, essentially. So here's your this is what we mean when we talk about loss. This is what we mean when we talk about a cross reference or theft. Here's some examples of what we mean by theft, etc. So it's supposed to explain and clarify. The problem, though, and this arose recently, is the back in 1996, the Supreme Court had a case called Stinson. And what Stinson said is the commentary is just as binding as the guidelines themselves back when the guidelines were binding, but courts still follow Stinson. Stinson said you have to follow the commentary too. They're equally binding on the guidelines unless they are inconsistent with the guidelines or they violate some constitutional provision. And every now and then,
when that happens, when
yes.
the commentary and the guidelines are at odds with each other, the court has said you must follow the guideline, not the commentary.
That's correct. That's correct. And that has become more apparent recently because of a Supreme Court case that had nothing to do with the guidelines, but had to do with agency or administrative law. And this was back in 2019 in a case called Kaiser versus Wilkie. The Supreme Court said that you can only look at agency regulations if the regulation that you can only look at commentary to agency regulations if the regulation itself was somehow ambiguous. But it had to be genuinely ambiguous. And you had to go through all these sorts of contortions to determine if it was genuinely ambiguous or not. You just couldn't say, I'm not really sure. It had to be genuinely ambiguous before you can even resort to the commentary. And if it wasn't genuinely ambiguous, then you could not resort to the commentary for any purpose. And so the big thing that
you can imagine how confusing that is to people who know what you're even talking about, which is
exactly
few, right. But to the general public and even to judges and lawyers, they have no idea what that means. Right.
So what ended up happening, it was actually here in the context of the fraud guidelines. It all had to do with what's loss. And before this year, prior iterations of the guidelines defined loss in the commentary. And the way the commission defines loss, as we could see here, is it's the greater of actual or intended loss. But that definition, it's now in the guideline itself. But historically, until prior to November 1, 2024, it was in the commentary. And so what ended up happening is a split among the circuits developed about whether the term loss was ambiguous or not. The Third Circuit, in a case called United States versus Banks, said loss is unambiguous. Loss means loss. Loss means actual loss. We all know that. Loss does not include the term intended loss. So because it's not ambiguous, we're not going to even look at the commentary. So this whole concept of intended loss thrown out the window. I think the 11th Circuit went the same way, and the 9th Circuit went the same way. But then there was the 6th Circuit said, no, loss is ambiguous. So we have to look at the commentary. And so the commentary says intent, so you could still use intended loss. And defendants never like using intended loss because that always aggravates the loss amount. You get
it aggravates it because it leaves it to the discretion of a judge and the prosecutors to say, well, we think that the evidence points to the fact that the defendant intended to do X, even if he didn't accomplish it.
Right.
And which is why the Third Circuit in Banks basically said, hey, no, we know the number. We know how much people lost, and that's the number.
Right.
And as you said, the 11th Circuit Ninth Circuit both agree. Sixth Circuit didn't agree.
Yeah.
It's a mess that none
So
of
it
these
creates.
circuits know what to do.
Right. It created a mess. And so it ended up back at the commission. And this is a weird thing about the commission. I'm just going to back up for 1 second. When the commission when it first came out back in the mid 80s, it was immediately challenged that it was unconstitutional. You have this little agency telling judges what to do. They're basically making laws because that's what a law does, tells a judge what to do. How to interpret the law, et cetera. And it was challenged. And some judges said, yeah, the guidelines, the Sentencing Commission and what it does, unconstitutional delegation of authority. Went all the way up to the Supreme Court. And the Supreme Court said, no, constitutional delegation of authority. It was a case called Mistretta versus Pennsylvania, I think. I can't remember, or United States versus Mistretta. It was the Mistretta case. And if
That's
the
Mistretta.
Correct.
Yes.
And it was an 8-1 decision. 8 of the justices said, yep, the commission is copacetic, constitutional, no problem. Except one justice, Justice Scalia. Justice Scalia dissented, and he said the commission is nothing more than a junior varsity Congress. And I happen to agree with him, because what's really interesting now, to come back full circle to the commentary and loss and all this stuff, is one of the things that the commission does is it resolves circuit splits. So when there's a circuit that goes one way, like the Sixth Circuit, and another that goes the other way, like the Third, then ultimately it's up to the commission, or traditionally it's been up to the commission, to resolve that issue. But these are legal issues. So not only, generally, it's the Supreme Court that resolves circuit splits, or Congress could change the law.
In fact, one of the principal ways that you can get the Supreme Court to review your case, and they only review maybe 0.5% of all the cases that are for which there are applications to it to be heard, is to say that there's a split in the circuits.
Right.
And therefore, they are the ultimate arbiter of that split. But as Justice Scalia pointed out, now we have the commission making determinations.
Right. And so the commission isn't just a junior varsity Congress, it's also a junior varsity Supreme Court. And so what the junior varsity Supreme Court did last year, when the split developed about whether the commentary is binding or not, and whether things are ambiguous, it did something kind of cheap. It took the definition, rather than really addressing the merits of the issue and the problems with intended loss that have always been percolating out there, and taking that head on, it just moved the commentary into the guideline itself. So now, which I think it was a really cheap way to resolve this issue. But now the definition of loss is in the guideline itself, so that Kaiser case no longer applies, and the commission doesn't have to deal with any of the issues regarding actual intended loss. It's there in the guidelines, so it's binding. End of the story. It just it was an unprincipled way, and by unprincipled I mean in the sense of addressing the merits of the issue about problems with intended loss, and there are many, versus actual loss that have always been out there. It just you use this Band-Aid to avoid the issue. But the issue is still there, though, because there's still commentary to the guidelines, and there's every single guideline, and there's dozens of them, has commentary. So the issue hasn't disappeared. They've resolved it for this one minor issue in the whole pantheon of sentencing guidelines issues, but it's still percolating out there for other guidelines, and even in this context, you could still challenge the commentary.
Let me expand on that for a moment. Yeah. Every guideline is written and is subject to the interpretation of the judges who review it.
Yeah.
And there are what we call, and I don't want to get too technical here, but there are what they call cross-references.
Yeah.
So that you can be looking down at one guideline and it has a cross-reference to another guideline, and you have to decide is the cross-reference applicable, not applicable? And this is where certainly most attorneys, if not all attorneys, need somebody like you to come in and help them understand how
Right.
and when the cross references are applicable or not.
Right.
Sentencing is going to be the most impactful thing that happens to a client.
Yes.
And one of the other topics, because we could talk about this for days, but and I know you do talk about it for days. In fact, you appear on a show, another podcast that talks frequently about this, right?
Yeah. Set for sentencing.
Set for sentencing, which is very entertaining and also very informative. But there are two other things that happen in sentencing today and have been occurring that are important to me. And that is for people to understand that the judge, in addition to imposing a term of incarceration, can impose what they call restitution and or forfeiture. Can you, in a generic way, explain to us what those topics mean and why they're so important to address?
Right. So, there's actually three different things. There's loss, restitution, and forfeiture that often are conflated or confused with each other. Loss is the measurement of the harm, somewhat related to the restitution issue, but not always. Restitution is the actual loss that a victim suffered, a particular victim or group of victims.
And how do we define, let me stop you for a moment. Yeah. How do we define who's a victim? And who does that determination? And are you allowed to contest that determination?
So the judge does that determination, and yes, you can contest that determination. What the issue about whether somebody is, at least for restitution purposes, and it's related to loss too, even though loss is a different metric, is what's called causation, or really what the lawyers call proximate causation. Did the defendant's conduct, was it related to, or did it cause, I mean, just to avoid all the legal jargon, did the defendant's conduct cause the alleged harm or the loss to this particular victim? If it didn't, or if it's too tangential, then that person isn't a victim of the defendant's conduct. And so the defendant cannot be ordered to pay restitution, or that amount cannot be included in the loss, the measure of harm for sentencing purposes. And you can contest that. You can contest that at sentencing. Generally, it occurs at the sentencing hearing, or it's part of the plea agreement. Very often it's negotiated ahead of time. As you had mentioned early in the podcast, over 97% of individuals that are sentenced under the guidelines have pled guilty. And most of those individuals, but not all, but most of them have pled pursuant to a plea agreement. The rest have pled what's called open or straight up. We could talk about that later if you'd like. But
we can talk about plea agreements so the cows come home. Because plea agreements are nonsensical. They don't really mean what they say. They're
don't take them.
And I've heard you talk about that, not taking them.
They're crap. They're crap. Go to trial or plead straight up. That's going to be on my gravestone.
I agree with you because and to a defendant who was told by his lawyer, here's the plea agreement with the government. You think as a defendant, it's binding upon the prosecution. And no matter whether a judge tells you it's not binding on me, they think it's binding. And then they get hit with enhancements and upward variances or anything else that they're not anticipating, and wind up, instead of a 5 to 40 sentence, they wind up with a 25-year sentence when they thought they were getting 5.
Right.
So I didn't mean to digress from where you
Right.
were.
No, but that's right. So restitution basically is the award that the judge imposes, or basically it's an order that the judge imposes as part of sentencing on the defendant to pay any damages. It's almost civil in nature, but we'll talk about that in a second. Supreme Court case that's pending right now on the issue. It's traditionally civil in nature, part of sentencing, usually resolved in the plea agreement. If not, it could be resolved at sentencing, although it doesn't need to be. There's a rule that allows you to delay resolution of the restitution amount up to 90 days after your sentencing. So sometimes in really complicated cases, you can resolve restitution in a separate hearing. But it results in a money judgment against the defendant. Or a civil judgment against the defendant, and they'll dock your commissary or your account when you're in prison, whatever money you might have if you get a custodial sentence, and it stays with you forever for pretty much the rest of your life. And these restitution orders can be significant in conspiracy cases, especially if there's a lot of defendants involved. These restitution amounts are ordered to be imposed joint and severally. And what that means is, let's say the restitution is $5 million and there's 5 defendants. So each of those defendants is responsible for the whole amount. But if any defendant pays like $1 million, then it reduces the amount by $1 million for everybody else, and don't get too much into the weeds.
And as a 20-year penalty,
yeah,
after you've completed your sentence.
Well, and it could be renewed.
Yes.
So at the end of that 20 years, so basically, if you haven't paid it, if you haven't paid off your restitution within that 20-year period, the Department of Justice will just renew the order, if you will, and it still stays with you forever until you pay it off, if that's even possible. And that's not possible. Most defendants never pay off their restitution amount and only pay just modest amounts towards it. There's a limit on how much the government can take out of your pay or any assets that you have in order to go to restitution. So that brings us to forfeiture. And forfeiture is I'm no expert in forfeiture. It's its own little world. But basically what it is any proceeds of the offense. This is separate from restitution. Any proceeds from the offense that were used to purchase like property or that were used as part of the offense. An easy example is in the child pornography context. If you used like a cell phone or a computer to access the child pornography, that is going to be subject to forfeiture. In other words, the government gets to take it. And that's a very easy burden for them to show, and you generally admit it as part of a plea agreement. If you're pleading guilty, you'll agree to any of the instrumentalities that you use to commit your crime are subject to forfeiture. But the problem is, computer, cell phone, okay, fine. But what about a house? If you, in a drug case, if you were selling drugs out of the house, that house can be subject to forfeiture. And that might be where your family lives. It's the risk you take. Of course, the judge is going to say, and the government's going to say, if you're committing some type of drug offense, selling or cooking drugs out of your home. But nonetheless, it's still something significant that there are expert attorneys out there that just focus on forfeiture issues that certainly can help in that regard. But so forfeiture is just, if you used something or you bought something from the proceeds of your crime, the government gets to take that from you. And that can happen even before sentencing occurs. That can happen very quickly, actually, just shortly after you're indicted. And that it can be just absolutely frightening. And there's all sorts of litigation around that. But that's different from restitution, which is order to pay the victim, which again is different than the loss amount. But coming back to restitution, what's really important is there's a development right now in the Supreme Court that everybody should be aware of regarding restitution. As I mentioned, it's generally or traditionally has been civil in nature. It's just a way for victims. The point of the restitution, there's something called the Mandatory Victim Restitution Act, and there's some other closely related act. I can't remember the acronym right now.
So those would be sections 3663, 3664 of Title 18.
Yeah. And the reason why Congress created those is supposed to make it easier for victims of criminal offenses to be made whole. If they were, you stole money from somebody or defrauded somebody of some assets or something like that. This way, victims didn't have to bring a separate civil action. This all could be resolved at one time as part of the criminal justice system. So what's interesting is there is now a Supreme Court case that's going to be heard on October 14th. It's called Allenbaugh, Ellingbburg versus United States. Supreme Court docket number is 24482. And you can go on SCOTUS blog and find this, for example, or just go to Supreme Court's website, find the case, and just type it into the docket search and you'll find it. But the issue there is whether criminal restitution under the Mandatory Victim Restitution Act is a penalty for purposes of the Constitution's ex post facto clause. I don't need to get in the weeds for that, but basically what the Supreme Court is being asked to determine is whether restitution really is criminal in nature rather than just civil. And the particular issue here is whether the ex post facto clause applies. If it's civil in nature, then the clause doesn't apply. But if it's criminal, then it does apply. But here's the bigger point. Here's the big point. And Justice Gorsuch has actually opined on this recently in some dissents that he's written. If restitution is criminal in nature, which it sure seems to be, because you're making a victim whole, part of the whole sentencing process, then the Sixth Amendment applies to that. Big deal. What does that mean? Well, if the Sixth Amendment applies to restitution, criminal restitution, then that means that amount of restitution must be determined by a jury and not by a judge.
So let me stop you. Let me stop you for one moment because I want to get this into context.
Yeah.
Some years ago, there was a case in which the penalty was greater than the initial indictment charged the person with. Mm-hmm. And the Supreme Court ultimately weighed in and said, well, listen, that has to be determined by a jury if you're going to enhance a sentence based upon these factors.
Yes.
And this is really following in that same path as that prior decision, right?
Precisely. Okay. This is Apprendi.
Yes.
And Apprendi, so it was an interesting case out of New Jersey, state case that had to do with racial animosity. It was a hate crime. And the issue there was this individual had burned, as I recall, he was a white supremacist, burned a cross or did some type of vandalism to a black family in his neighborhood. So he was charged with arson or the equivalent thereof. He had a 10-year statutory maximum. He goes to sentencing, and at sentencing, the Supreme Court or the government for the first time says, by the way, Judge, this guy's a racist. He's a white supremacist. We think that this quote unquote sentencing enhancement for racial animosity should apply. And the judge applied it. And what happens is when you apply that under New Jersey law, it doubles the stat max. So his stat max went from 10 years. He walked into sentencing thinking worst case scenario was 10 years. And now with this finding by a judge, by a preponderance of the evidence without the rules of evidence applying, because at sentencing, everything comes in. This always shocks people. There's no hearsay rule or hearsay exception or anything like that. Anything could come in. As long as you meet it by a preponderance of the evidence, not beyond a reasonable doubt, that's enough. And that's what the judge found here. Okay, you say so. He was racist. Okay, fine. I'm going to double his stat max. It's now 20 years. So I could sentence him up to 20 years. I give him 12 years. And the Supreme Court said, time out. that violate? And it was a 5-4 decision. It wasn't a unanimous decision, which kind of was surprising to me. But 5-4 Supreme Court said no. When you increase the stat max, that factor that increases the stat max must be treated as an element of the crime. Now back to restitution. So we're at restitution. This is as I'm going to take everybody down maybe not down the rabbit hole, but this has the potential of exploding our current sentencing regime, the Allenbaugh case, because if restitution is which means that amount must be determined by a jury, then it would seem to stand to reason. Same thing with loss amount. Specifying the indictment what the amount of wire fraud is very important, because it's the loss under the guidelines. That loss amount is what determines or has a lot of weight on what the ultimate sentence is, even though the guidelines are, as we've been discussing, merely advisory. Courts still must consider them, and so the guideline range has what's called an anchoring effect. And we can see this statistically. I should have done a visualization. I didn't, but as wherever that guideline range is, you have a cluster of sentences around that range, and so that's what that anchoring effect is. So as naturally as the amount of loss goes up, so does the sentence. But now the Allenbaugh case has the potential of showing that sentencing factors. Now we're back to Apprendi, and we're back to Booker, and we're going to have to finish what Booker or what Apprendi really didn't finish was, okay, just because you increase the stat max, that's certainly a sentencing factor. But what about any factor that increases the sentence? Scalia, before he passed away, he had written a dissenting opinion that was also joined by Ginsburg and Thomas, stating that any factor that increases the sentence must be determined by the jury and not a judge. And so why is that? If most individuals plead guilty, what relevance does that have then? If you're never going to a jury for pleading guilty. Well, now it gives you a lot more leverage and negotiating power on what's going to go into that plea agreement. And you don't have to just, excuse the phrase, bend over and take it with respect to plea agreements now when they're just alleging a particular loss amount or drug amount or number of victims or any of these other factors. So Allenbaugh, through restitution, may end up upending once again the whole sentencing regime. And I hope it does, because it's time we get it right. It's far past time we get this right. Yeah.
Of course, in 2005, the Supreme Court had no guts. If they found that the guidelines were unconstitutional, they should have struck them down and go back.
That should have been it. You're right.
And go back to the drawing board. The argument in Allenbaugh is somewhat analogous to forfeiture in our society. Normally, the government has to set forth what they are intending to forfeit and asking the jury to do so for them. Mm-hmm. But now, I think Allenbaugh should conclude that the government has to prove loss. So I'll give you and by the way, let me just mention one thing. You talked about a restitution hearing not taking place at sentencing and can be done 90 days later. Normally, the defendant's not around at that point. They're off in prison.
Right.
So they don't even get to really participate in the process. And judges don't pay attention to the 90 days oftentimes. So all that's – but let me ask you this. I'm a person with psychological problems. Mm-hmm. And I've had them since I'm 14 years of age. And by the time I'm 20-something, I go and I participate in something which I say further psychologically impaired me.
Okay.
how and if the person who psychologically impaired them in their 20s is then punished criminally, how do we determine victimization of that individual? Is it the victimization that you can prove from the time that they were involved with these people who were criminally convicted, or from the time that they were 14 going forward?
That's a really good question. So in sex abuse cases and in child pornography cases, it's generally the restitution amount is premised sometimes, not always, but sometimes premised on future costs for any type of therapy that the individual may need.
And
So
how does that get established?
that it gets established at the restitution hearing or part of the sentencing hearing.
Right, but I'm saying how would you establish that at a restitution hearing?
So what has happened is we've had experts so and so evaluate the victim, and they're going to need therapy for X amount of years, and here's the reasonable cost analysis, unless it's challenged.
Right. So that's the second part of my question.
Yeah.
Can you challenge that?
Yes, absolutely. You can absolutely challenge.
How do you do that?
It's sometimes it's going to be ugly. You're going to have to bring this purported victim in, or the victim, and cross-examine them, or the expert. You're allowed to do that, or just have your own expert say, "Look, this is completely unjustified. These are inflated amounts, and blah blah blah." This person doesn't need either that amount of therapy for that long period of time, or this is too speculative. I mean, that's one thing that the court is not allowed to do, is speculate. Just can't speculate on damages. And, it's really not up to the defendant to come up with an alternative number. But what the defendant can do is just poke holes in the theory of whatever the restitution claim is. And it doesn't even have to be in the context of sex offenses. It could be potentially like lost wages or future lost profits and stuff like that. That can be very speculative, that you often see victims treating as part of a restitution award. But yeah, you can challenge this. Absolutely.
Well, if you were bringing a case where somebody was paralyzed in an accident, you brought a civil action against them.
Yeah.
As part of your proof as the plaintiff, the person injured, you would have to bring in experts to say, hey, they need this kind of care for the rest of their lives. Here's how much it costs to do that.
Right. Right. You would have to bring in experts.
And juries are capable of coming up with decisions.
Right.
Which are subject to being reviewed by appellate courts and the like. Why can't we, as Allenbaugh suggests, hold the government, the prosecution, to their feet to the fire by saying, prove it?
Yeah, there's no reason not to. What the government is going to say, and what some members of the Supreme Court might say, and this, I'm not advocating for this argument. I think it's an irrelevant argument, but I see it a lot, is, well, it's impractical. Now, every sentencing involving any restitution amount is going to become a mini trial. My response is, so what?
So what? Exactly.
Yeah.
And that's what it's supposed to be. Why do you have MVRA 3663, 3664, if not to give a defendant a chance to challenge the determination of loss and or victims?
Right. Exactly. And that's all part of due process. And that's what Allenbaugh is going to be discussing, is how much process is due. And one thing I would just add to your very astute comparison to a civil jury, if I'm going to sue somebody for damages civilly, not only is the burden of proof is still the same, just beyond a preponderance of the evidence, but I have to not only provide evidence, but I am limited by the rules of evidence. So the rules of procedures. So there's certain procedural restraints, and there's certain evidentiary restraints that I am limited to, that I have to follow, because the point is, so I don't get what's called a windfall. I have to prove everything up, but subject to all these evidentiary and procedural constraints. That is not the case at sentencing. And this always stuns people. The part of the in our criminal justice system where we are taking away from you your liberty and your property, you would think would be subject to the highest standards of, highest burden of proof, procedure, evidentiary rules, and all that stuff. And in fact, it is the lowest. It is easier to get a restitution award as a victim through the criminal justice process than it is to file a civil lawsuit, which reverses everything on its head. Because at sentencing, and even and this is what's going to be discussed in Ellenberg, at sentencing and the restitution hearing, there are the only burden of proof is beyond a reasonable doubt. By the way, jury determination civilly, so you don't have that at the restitution hearing. It's just the judge beyond a reasonable doubt, with no rules of evidence. There are no rules of evidence that apply at sentencing, and there are no procedural rules either. Anything comes in, whatever the government wants to throw up there, see what sticks, and you as the defendant are having to, just try to pull all this stuff off the wall that the government keeps throwing up there. Or
just a clarification, there is no burden of proof beyond a reasonable doubt at sentencing.
Correct. I'm sorry if I said that. I meant preponderance of the evidence. Yeah.
Right. So preponderance of the evidence essentially means 50.1%.
Correct.
Believable versus not.
Correct.
And we know as a practical matter that most district court judges, accept whatever the government throws against that wall as though it were the gospel.
Correct.
So that's one of the things that Ellenberg is so important, why it's so important, is we now can put ourselves in a position of forcing prosecutors to actually prove what they contend with regard to restitution, with regard to,
yes, if we decide to go to trial.
Yes.
If we decide to go to trial,
or even if you're taken as what you called an open plea. Explain what that means, by the way.
Okay, so good. Thank you for asking. But probably that's half of my gravestone. Go to trial or take the open plea. forget plea agreements. So I've been surprised over the years to learn how few people even know what this is. It's right in Rule 11, Federal Rule of Criminal Procedure 11. So you can plead guilty pursuant to a plea agreement. That's not the only way you can plead guilty. You can also plead open or straight up. And what that means is, I'm going to walk into court, whatever the indictment says, I'm going to plead guilty to that. No plea agreement with the government. Well, why would you ever do that? Well, one of the big reasons why you would do that is when you plead guilty pursuant to a plea agreement with the government, you have to waive not only your trial, which you always do if you're going to plead guilty, but now you have to waive your right to appeal. You have to waive your right to collaterally attack a lot of stuff. And the government generally is going to require you to stipulate to certain facts that you might not want to stipulate to. The loss amount in a fraud case, the drug amount in a drug case, the number of victims, et cetera. And you may also have to stipulate to restitution. So you're not going to be able to fight that. Okay, I agree. Restitution is $3.5 million or whatever the term is. So you waive all of that stuff, and in return, you generally get nothing, because while in the plea agreement, all of that is binding on the parties, but you waive all of that. You waive your safety nets and everything by pleading pursuant to what I'll call a non-binding plea agreement. The C pleas are the binding ones.
Right. So you're referring to an 11C1C plea,
Correct.
Which says to the judge, we've agreed upon this, and you can sentence him to what we've agreed upon, or you can reject it.
Right.
But that's what we want you to do. And since most judges follow the agreements reached by prosecutors, the 11C1Cs will generally work.
Yep.
I just actually came across a district in the Northern District of Georgia where they rarely ever accept an 11C1C plea. That's
Mm.
a different issue. You mentioned collateral issues.
Yep.
So to the uninitiated or even to the attorneys who might not know what that means, what does that term mean?
Well, it's another way to attack your sentence or conviction, and so you have the right to appeal. So you get you go to trial, you're convicted, and then you're sentenced to 20 years, whatever now you can go up and appeal that and say that I shouldn't have been convicted for X, Y, and Z, or the sentence was too long, or there's some procedural error in that. Um, you lose on appeal, everything gets affirmed. Now you can collaterally, what's called a collateral attack. Generally, and this isn't subject to waiver, generally the collateral attacks have to do with your attorney. You would say, my attorney was ineffective. So I had ineffective assistance of counsel. And if you can prove that, which is very difficult to prove, it's a super high burden, then you would be entitled to at least a new trial, or in some cases, a new sentencing. But there are other issues that have to do with for example, if the law changes and you're on appeal, let's say, and the law has changed, and now what you did is no longer considered a crime. The Simonelli case did this in a lot of, I won't go into it, but the Simonelli case did this for a lot of white collar cases. You would be able to raise that, collaterally attack, say, look, the law is no longer valid. You waive that. So that's one issue. And there are other kind of arcane ways to collaterally attack. It's just basically a way to attack your sentence or conviction outside of an appeal. And it generally occurs after the appeal is over. The number one way, again, is ineffective assistance of counsel, but that's never waived. You cannot waive that as part of a plea agreement. Even if you wrote it down, I waived my right to collaterally attack, that no one's going to recognize that waiver. But that's the general way to collaterally attack, other than constitutional issues, some other types of procedural issues that you can raise. They're very arcane, but you may want to raise them, and you waive those other arcane ways to attack your conviction if you enter a plea agreement.
And to your point, if you take an open plea, you reserve the right to do all those things as if you went to trial.
And one big, actually, just this reminded me. So one big collateral attack that I've seen early in the pandemic stages that was required to be waived, but generally isn't any longer, is what's called compassionate release. And compassionate release is a separate mechanism where if you can demonstrate some extraordinary reasons, generally have to do with age or health, you can ask your judge to lower your sentence, actually, to time served. And that's if you will, a collateral attack that doesn't have to do with the merits of your case and doesn't have to do with appeal. Some districts were requiring defendants to waive that as part of a plea agreement during the pandemic, because so many individuals rightfully were bringing motions for compassionate release because of the pandemic, because the Bureau of Prisons is, crap, and they didn't want to get sick and die, which a lot of them did during the pandemic. So that's another big way of collateral attack that you have to watch out for and make sure that that's not waived, because you don't know what's going to happen to you, 5-10 years down the road, health wise, or there may be other issues completely unrelated to the merits of your case that you would like to raise.
We have in my opinion, a very good sentencing commission right now, who are being much more progressive than prior iterations.
Absolutely.
And are recommending things, but sometimes even when they recommend and it passes into the law, they recommend by May. The law, if it's not changed by the Congress, it goes into the law, becomes a law in November. But sometimes if you've given up your right to collaterally attack, whatever they may change, that may impact on you, you've waived the right to seek relief from. So
Right. And so, yeah, I think what you're talking about, another collateral attack, and thank you for raising this, is that sometimes the commission will make changes to the guidelines and make them retroactive.
yes,
So one of the big ones was the 0-point offender downward adjustment. It's one of these rare times that this very proactive commission, from as much as I criticize the commission, this particular set of commissioners, I absolutely agree with you, very progressive and finally attacking some big ticket items and addressing big ticket items. The 0-point offender adjustment is a 2-level downward adjustment for those that had 0 criminal history points and meet a bunch of other criteria. Well, they made that retroactive. So if you had been sentenced before it went into effect and you otherwise qualify for that, you could bring a motion now to have your sentence reduced for being a 0-point offender, even if you had been sentenced years ago. If you waive your right to collaterally attack your sentence, that would be included. So you would be waiving any retroactive amendments to the guidelines that could apply to you. And that's something that the commission has been doing more frequently now, is making amendments to the guidelines retroactive. So that's another collateral attack that you don't want to waive, or you have to be aware of, that if you do waive it, that's what it means.
Mark, this is a good introduction, not certainly sufficient to cover the topic, but we should do this again and explore more of these issues. I do want to point out that I'm looking forward to seeing your new book that's coming out. Tell me about that.
Yes. So, yeah, thank you. This is the Federal Prison Guidebook, which is actually out now. For years, I've worked with Alan Ellis, and this is I have a picture up here on the screen. And I'm now a co-editor of it along with Walt Pavlo, and it's a great tool, for anybody who's been practicing out there. I'm sure everybody is aware of this. Alan has been publishing it now for decades, and the newest edition just came out in June. I encourage everybody to go get a copy. You can go just to James Publishing. You put in Stats 25 and get 15% off. But it's a great resource. We've updated it. A lot of the issues that you and I have been talking about are in the book. Also, we have updated all the. It's basically like a travel guide, if you will, for all the prisons out there, all the federal prisons. So we've updated our summaries of each of the prisons, and have also provided an analysis of their population trends over the last 5 years for every single prison out there. So
a very helpful set of information for both the attorney who's representing a client in sentencing and for the clients once they're in prison.
Correct. Yeah.
Thank you so much for appearing. We'll certainly stay in touch, and I hope that you'll come back and join us in the future.
Well, Robert, thank you very much for having me. It's been a pleasure.
Thanks, Mark.
Okay, take care.
We'll be back next week with another episode of Injustice for All. We'll be dealing with another topic. As I've mentioned repeatedly, this show is not only about people who have been to prison, who have been freed because of some injustice, but it's an educational forum for you to understand how the system is supposed to work and why it does not frequently work. We'll see you next week. Thank you.